Lordship, regarding the physical,
just forget about it.
physical harassment.
Statement है तो allegation तो है as regards demand of dowry after the marriage.
So
Page
after
1210 161 का जो statement है, this is good enough for now.
Lordship, जो स्टेटमेंट है उसमें अगर आप देखें तो डिमांड फ्रॉम हर कहीं भी मेंशन नहीं है. She is saying that the daughter told me that demand was being made from her. So she is a hearsay witness. The complainant never said कि मुझसे कोई डिमांड की गई है.
Now I am hearing this finally. हाँ बताइए.
So the complainant never said कि मुझसे कभी भी इन्होंने फाइनली कोई डिमांड करी है from the Lordship, the matter was briefly heard.
They had directed to prepare a list.
They had been directed to refer to the pages from charge sheet and another.
Yeah.
Lordship, Advocate Shanno Khan is in the High Court mediation here training, so she's not able to be present over here. But Lordship, with all due respect, I seek your permission to argue in person.
Please.
Yeah, thank you so much.
Lordship, may I start?
Yes.
Lordship,
What is IE 13420 of 22? Application for calling final charge sheet. Here for stay, dismissal, direction, vacating stay. और vacating stay है इनको सुनते हैं. On vacating stay. When was the stay granted?
On 5th December 2023. The stay was basically there because the reply was not filed by me. There was a delay in the filing of the reply. But thereafter, on 22nd of December, I have filed the reply, and the stay was as an interim measure till the reply was filed.
Yes.
As per your Lordship's query on the last date, I will only answer that and take you through the important pages of the challan. Your Lordship, I will just take 2 minutes before taking you through the challan to give a brief background in few lines. Lordship, let us see page number 80, page number 158. I had sent an email to NCW on 3rd June 2021, and the same complaint was registered by NCW on 7th June 2021. That is just before I had sent the complaint just after 5 days of my daughter's death. Lordship, let us see page number 159. Sorry. 159. It's the brief complaint. My late daughter Aishwarya Mayank Gupta was married in Indore, Madhya Pradesh 4 months ago. She passed away on 28th May 2021 under mysterious circumstances. The family she was married into is from a medical background and own a hospital in Indore, Madhya Pradesh. There were many suspicious activities being carried out by her in-laws within the hospital while she was being treated under their supervision. Her in-laws are locally influential people, and I am a single mother who had been seeing and observing all the suspicious activities being carried out in their hospital while treating my daughter, while I was physically present over there and being constantly threatened by them. I need urgent help to intervene in the matter to get justice for my daughter, as their suspicious activities continue and pose a threat to my sons and my life. Please revert as soon as possible. After much efforts, I was able to register this FIR in Pune. After my complaint to the NCW, NCW had forwarded this complaint to the SP of Indore on 8th June 2021, but there was no response from the Indore police authorities. Therefore, after waiting for almost a month, NCW then forwarded the same complaint to the Commissioner of Police in Pune and asked them to take cognizance of the complaint. Let us see page number 160, Lordship, in which NCW has given this letter to Commissioner of Police of Pune. So after this, the FIR was registered in Pune. A zero FIR was registered under sections 304B, 498A, 201, 204, 120B, and 34. And the same was forwarded to Indore. And finally, it was registered in Indore on 28/7/2021. So as falsely stated by the petitioners in their brief summary that there was a delay of 1.5 months, I would like to bring it to your notice that there was no delay, but the delay was from my part, but the delay was because of the investigating agencies. Lordship, let us, before I start with the challan pages, I would like to bring to your notice that after 7 months of the registration of the FIR, the police had not acted upon the case. That's why I had approached Honorable High Court in the month of February 2022 with a writ petition.
Abhi, so now everything has been done. Now investigation has been
Yeah,
completed.
I
Charge
would
sheet
just
has
like
been
to,
filed.
yes, yes,
Let us
sir.
confine to the allegations in the charge sheet.
Yes, sir. Lordship, let us see page number 189. This is the Panchnama and all the important call recordings and WhatsApp messages related to the mental and physical harassment, which is there present in Aishwarya's phone, has been duly submitted by me to the IO with 65B certificate. Yeah. Page 781 is another Panchnama in which I have submitted the mobile phone of Aishwarya and a 128 GB pen drive with 65B certificate. Lordship, let us see page number 838. In this letter, the IO has sent to the forensic department, wherein he has mentioned that pen drive of 64 GB, 2 numbers, and 32 GB, 2 numbers. Whereas in the Panchnama, I had submitted one pen drive of 32 GB and one pen drive of 28 GB. So I fail to understand how come the pen drives were changed and submitted to the forensic department. Page number 839 is the forensic lab receipt, wherein it is mentioned that 64 GB 2 pen drives and 32 GB 2 pen drives have been submitted. Also, I would like to bring to your notice that I had submitted almost 207 pages of WhatsApp chats, which is mentioned in the Panchnama, but the forensic department has received only 144 pages of WhatsApp, hard copies of WhatsApp chats. The WhatsApp chats of Aishwarya with her husband Mayank, Aishwarya with her brother Akash, and Aishwarya with her maternal aunt Sejal Khandelwal were never forwarded to the forensic department.
So what is, see, we are not
Yes.
examining whether the investigation has been correct or not. Now the
Yes,
investigation is complete. Now there is a charge sheet.
Yes, sir. Yeah. So I'll take you to the chats as per the challan pages.
Yes.
Yes. Lordship, there are call recordings also, which are there, like, important call recordings, and Aishwarya's phone is submitted in the challan. So it, though the call recordings are not, the hard copies are not there here, but I have created a synopsis of the call recordings in this document which I have filed on 6th
All
February.
recordings between whom?
Between Aishwarya and her mother, Aishwarya and her brother, Aishwarya and her husband, Aishwarya and her maternal aunt. Like, it's Aishwarya's phone. So it's between Aishwarya and all the related persons.
Yes.
Yeah. Lordship, on 5/10/2020, Aishwarya had called Smita Khandelwal, her maternal aunt, and through her phone, Aarti, had mentioned that Pooja Gupta insulted her saying that आप पैसे को देख रहे हो, आप ये नहीं देख रहे कि हमारी इज्जत है, स्टेटस है, पोजीशन है. This has been mentioned in the FIR as well.
That is your harassment, not of the deceased.
I'm just coming to the point, Lordship.
See the harassment of the deceased.
Lordship,
Yes.
may I interrupt?
The
The last date, Lordship had directed them to only limit themselves to the charge sheet. Now they are referring to their own interpretation and their own summary.
No, these fault recordings are there in the challan, Lordship.
But these are all recordings with the mother-in-law as regards arrangement and the articles to be paid at the time of dowry. I am concerned with the demands made from the deceased for dowry.
Okay, from the deceased.
From the deceased.
Okay. So, Lordship, there are these important emails which have been exchanged.
Are they part of the
Yes,
charge sheet?
it's part of the charge sheet.
This page number?
Yeah. Page number 368 and 369. This is email sent by accused number 2, Dr. Sanjay Gupta, to the maternal uncle of Aishwarya, in which he has written that there was no demand as such made by them. But Lordship, please see, let us see page number 369, where he has written in point number 5, last line, as we are wanting her to spend a small sum of 30 to 40,000 for her own daughter's clothing.
And she is reading midway, Lordship. She should read this entire sentence.
I'll complete. Lordship, page number 363 onwards is the reply to the email sent by Dr. Sanjay Gupta. And this reply is given by me, which mentions the total dowry demands made by accused Mrs. Pooja Gupta. Lordship, please see page number 363, point number 2. Mrs. Gupta had told her to buy at least 2 gold bangles along with sets for Aishwarya, as she would need to wear it so as to look like a newly wedded girl. Point number 4. Mrs. Gupta had said that she would purchase all those things from Indore and Aarti would reimburse the amount. Page number 364, let us see point number 6. Mrs. Gupta asked her to make 21 boxes, preferably wooden boxes.
This is prior to the marriage. Is there any material that demand for dowry was made after the marriage?
After the marriage.
Lordship, and this email was never sent. She is not mentioned.
Yes, Lordship, I'll just mention one more thing. The original email sent by Dr. Sanjay Gupta has been forged and submitted in the challan by Dr. Sanjay Gupta, which is on page number 672.
Yes.
Lordship, all the words and sentences in this email have been forged and submitted. The same original email which was submitted by me, that particular email has been forged and submitted in this page, 672 and 673 of the challan.
This is again prior to the marriage.
Yes, sir.
I'm asking you demand
yes.
of dowry subsequent to the marriage.
Yeah, when Aishwarya came to Pune, that time she came and she told everything in person. Lordship, please refer page 327, chats with Aishwarya and Akash. Akash is her brother. Don't tell mummy that I called you and that something happened here. I will come to Pune tomorrow and tell her in person.
This doesn't say demand of dowry was made from her.
Lordship, she has been mentioning mental and physical torture and
Where?
harassment.
Where is that mentioned? This is what I want to know.
Yes, sir. Yes, sir. Lordship, please uh, let us see page number 349. This is the chat between Aishwarya and her husband Mayank. If you feel me or my family are mentally torturing you, then there is no need to come back. I am ready to face the legal proceedings as you said. Come back only if you take me as your husband life partner. I don't want you to be in any obligation or compulsion to stay with me. I very clearly told you Indore is a comparatively smaller town. Marry me only if you're free to come here. I or anyone from my family never forced you to marry me or do anything else. We tried to give you as much respect and acceptance as we could. We tried our best to treat you as our family. You are free to stay there if you are not happy. This is when Aishwarya had come to Pune. That time these chats are with mine. उसी पेज में नीचे think properly and then only come back. Lordship, page number 348. Again, Mayank Gupta is saying, I have only one thing to say. If at all you are not happy or not willing to come back, you are free to do so. If you choose to come back, then I don't want to have threats of legal actions and stuff. You want to go to the court, I'm ready to face all this and I would fight it out. Me and my family have never done any mental cruelty to you. This means Aishwarya had addressed the mental cruelty episodes to her husband Mayank. And that is why this particular line has been said over here. Lordship, let us see page number 346. Mayank Gupta, you decide once and for all. Part ways, be happy and have a healthy life. Be the way we are now, together for the world but away from each other. This speaks a lot about their relationship, Lordship. Let us see page number 341, towards the end of the page, where Aishwarya is saying, if you really want to know how it actually goes, then you should have experienced it and let me know. If any newlywed wife would take your irritated behavior every night when she gets close to you and calls out your name. I never cribbed about it. Let us see page number 340. Top of the page, Aishwarya is mentioning expecting you to spend time with us, expecting you to spend time with you and asking you to behave good with me is not wrong. Towards the end of the page, Mayank Gupta says, extremely sorry, working on my irritation management. Aishwarya, this behavior reminds me of my dad. He used to behave the same way with my mom. Mayank Gupta, sorry, I would not get down to that level. Again, Mayank Gupta says, extremely sorry. You continue to neki kar juta kha. Lordship, regarding the physical,
just forget about it.
Physical harassment.
Statement है तो allegation तो है as regards demand of dowry after the marriage.
So after
page 1210 161 का जो statement है, this is good enough for now.
Lordship, जो statement है उसमें अगर आप देखें तो डिमांड फ्रॉम हर कहीं भी मेंशन नहीं है. She is saying that the daughter told me that the one was being made from her. So she is a hearsay witness. The complainant never said कि मुझसे कोई डिमांड की गई है.
Now I am hearing this finally, हाँ? बताइए.
So the complainant never said कि मुझसे कभी भी इन्होंने फाइनली कोई डिमांड करी है from the date of marriage until the date of death. उन्होंने ये कहा है कि मेरी डॉटर ने मुझे बताया कि उससे डिमांड की करी गई है. अभी जितने इन्होंने चैट्स पढ़े हैं लॉर्डशिप, उन चैट्स में कहीं भी डिमांड की कोई भी बात नहीं हुई. कहीं भी कोई हैरेसमेंट ऑफ अ काइंड व्हिच वुड फॉल अंडर द टू लिम्स ऑफ 498 कहीं भी नहीं है. 498 का सबसेक्शन 1 सेज there should be cruelty of a form which would मतलब endanger the life or limb of the person or compel her to commit suicide.
Dowry Prohibition Act.
Dowry Prohibition Act नहीं है, सिर्फ 498A है. उस तरह की कोई भी क्रुएल्टी इन्होंने जो स्टेटमेंट्स अभी बताए हैं उसमें कहीं भी परिलक्षित नहीं. Lordship, even regarding the so-called demand, what they are saying, entire statement में कहीं भी ये मेंशन नहीं है कि what was the dowry demanded. पूरे स्टेटमेंट में कहा इन्होंने क्या कि
Is that necessary?
it is a very essential ingredient, Lordship, because अगर आप बताओगे ही नहीं कि क्या डाउरी डिमांड हुई है, अगर आप डाउरी डिमांड क्या है यही नहीं बता रहे हो, आप किससे कब डिमांड की गई उसका ही कोई मेंशन नहीं है, इनसे नहीं करी गई ये तो ऑन रिकॉर्ड है, इन्होंने कहीं भी ऐसा स्टेटमेंट दिया ही नहीं है कि इनसे डाउरी डिमांड करी. डॉटर से डिमांड करी इज कंप्लीटली हियर से. डॉटर का एकमात्र
वो तो बोल दिया आपने, बार बार रिपीट मत करो.
मैं
एक चीज एक बार बोलिए.
वो सर लॉर्डशिप इसलिए बोल रहा हूँ क्योंकि डॉटर का जो एकमात्र स्टेटमेंट रिकॉर्ड पे है लॉर्डशिप, डॉटर का एकमात्र स्टेटमेंट वो इसकी कन्वर्सेशन से, व्हाट्सएप कन्वर्सेशंस, एंड दैट कन्वर्सेशंस नोवेयर सेज कि कोई भी मुझसे डिमांड की गई है. ऑन द लास्ट डेट ऑफ हियरिंग लॉर्डशिप आई हैड साइटेड इंस्टेंसेस
अबाउट लास्ट डेट. आज बताइए.
आज मैं बताता हूँ लॉर्डशिप. उसमें मैंने इंस्टेंसेस दिखाए हैं जिसमें on the opposite the wife is making demands from her husband which is natural and the husband is fulfilling them. Google पे मुझे इतने पैसे कर दो, मुझे लैपटॉप दिला दो, all those are part of this conversation. So I have briefly given a summary along with some judgments over here. May I kindly refer to that? Lordship, if your lordship kindly turns to page number 19.
No, our written arguments required to contain dialogues also.
No.
There is no greater tyranny than what is perpetuated under the shield of the law and in the name of justice. If you are giving written arguments, give it on fact.
Well, lordship, may kindly ignore that part. Basically, actually,
give it for the court, not for the petitioner. Yes,
lordship. So, if your lordship kindly looks at page number 19 of these arguments, I have extracted the relevant parts and mentioned the page numbers in charge sheet. The undisputed conversation shows that on the other hand, there were transfers being made by the husband to the wife. There is not a single transfer from either the complainant or her daughter to the family of the accused. That is a very important consideration.
So you say fulfillment of the demand is necessary for this offense.
Fulfillment of the demand and demand तो कहीं है ही नहीं. Demand has never been mentioned in any of the chats. And the conduct is such that there has been an opposite transfer. So it is very unlikely that a person जो dowry demand कर रहा है, on the other hand he is transferring money to the complainant. Lordship, secondly, if you lordship kindly look at page number 25 of the written arguments and also the page number 76 and 77 of the charge sheet, which is the conclusion drawn so far as the marriage expenses are concerned. Usme lordship, the police has calculated the total of all the bills submitted by both parties and come to the conclusions कि 11 lakhs के total bills जो हैं ये complainant ने submit किए थे so far as marriage was concerned and 51 lakhs के bills जो हैं वो accused की तरफ से marriage expenses को लेकर के submit किए गए हैं. There have been further comments in page 76 and 77 जिसमें कहते हैं कि many of the bills are repetitive. We have carefully extracted those bills, lordship. Page number 27 में there is instance of around 30 bills which are repetitions. तो आपका जो conduct है lordship, इनका complainant का, which is that it is a false implication, वो इससे समझ में आता है कि आप तो exaggerated bill amounts दे रहे हैं. आपने same bill को page number 208 और page 302 में लगाया है. Similarly 232 and 301 में लगाया है. Same, exact same bills.
ठीक है.
तो ये lordship, the total of such bills is more than 4 lakh rupees. 11 में से 4 lakhs तो ऐसे bill है lordship. फिर bills who are in the name of some other person who are not relevant to the case, ऐसे bills around 3.5 lakhs हैं. उसकी भी मैंने summary table दी है lordship.
This is prior to the marriage.
This is prior to the marriage because they that shows our conduct lordship and that showed their conduct कि उन्होंने किस तरह की forged document submit
How
किए.
much is conduct relevant in criminal proceedings?
Lordship, my conduct may not be as relevant, but because I am alleging false implication, इसीलिए मैं सर ये highlight कर रहा हूँ. Lordship, now expenses which are from 3 to 4 years prior to marriage, इनके घर में जितने bills रखे थे ये सब इन्होंने submit कर दिए. Around 1 lakh rupees bills of such kind of expenses are also there. I have given a proper table of the same. So, lordship, on the one hand, we have submitted bona fide bills of 51 lakh rupees. A party who's spending 51 lakhs in marriage, वो dowry की demand इनके accordingly कर रही है. और जबकि इन्होंने मैरिज में स्पेंडिंग इज barely 3-4 लाख रुपीस.
Spending in a marriage and spending for the other side is a different thing.
Right.
You spend in the marriage, you call hundreds of people, you spend on them. How is that relevant for the
So Lordship,
expenses of marriage?
let me come to spending after marriage. Spending after marriage, even the prosecution story doesn't say कि इनके जो medical expenditure हुआ है, her medical treatment lasted for over a month. And उस पीरियड में इन्होंने 1 रुपया भी स्पेंड किया हो ऑन एनी मेडिसिन, ऑन एनी चिकित्सा, वो ये बता दें. पूरा
पीरियड का तो एलिगेशन है भी नहीं.
लॉर्डशिप,
डिमांड तो उसके पहले हुई है.
नहीं, इनका कहना ये है कि भाई हम लोग इनसे डाउरी डिमांड कर रहे थे. तो ऑन दी वन हैंड वी आर डिमांडिंग डाउरी एंड ऑन दी अदर हैंड 10 लाख रुपीस एट मयंक हॉस्पिटल वाज स्पेंट फॉर हर ट्रीटमेंट. इवन दे डू नॉट कंट्रोवर्ट सच एलिगेशंस. बॉम्बे हॉस्पिटल के अंदर 2.5 lakhs ऑफ treatment expenses were there, which were reimbursed from the insurance company. But the Mayank hospital expenses amounting to 10 lakh rupees were borne by us. Prosecution story भी नहीं है कि उन्होंने bear किया हो. So lordship, एक accused जो कि bona fidely अपनी daughter in law के लिए इतना अमाउंट स्पेंड कर रहे हैं ट्रीटमेंट के लिए, ट्रीटिंग थिंकिंग इट इज देयर ड्यूटी टू डू द सेम, उनके खिलाफ इन्होंने डाउरी का एलिगेशन लगा दिया और 1.5 महीने बाद लगाया. दे आर सेइंग कि 4 दिन बाद हमने शिकायत करी. If your lordship looks at the content of what email they did to the women and child development ministry, उसमें डाउरी शब्द भी नहीं है, उसमें डिमांड का भी कोई शब्द नहीं है, उसमें फिजिकल वायलेंस का भी कुछ नहीं है. जस्ट अ कंजेक्चर हैज बीन डन कि देयर इज सस्पिशियस एक्टिविटीज गोइंग ऑन इन द हॉस्पिटल. उसके बारे में मैं आपको सूचना दे रही हूँ. एंड देयर स्टोरी कंप्लीटली चेंजेस फ्रॉम टाइम टू टाइम. इनिशियली दे वर एलिजिंग कि ये कोल्ड ब्लडेड मर्डर है, व्हेन 302 का कोई केस मेड आउट नहीं है. देन दे सेड कि इट इज अ डाउरी डेथ. Even their reply starts with that कि there is a possibility कि ये dowry date है, possibility of this and this. And if your lordship looks at
reply को तो इग्नोर कर चुके हैं.
ठीक, then let me. अब lordship, the second thing which I want to draw your lordship attention is कि इसमें witnesses कौन है lordship. इसमें witnesses complainant जो कि completely here से है, इनका son जो कि completely here से है, इनके जो relatives हैं, even their relatives have not supported the story. May I kindly draw your attention towards the statement of their brother, who is Umesh Khandelwal. It is on page number 1226.
देखिए,
हाँ, उन्होंने बोला कि हम रोका मैरिज सब जगह उपस्थित थे, डाउरी से रिलेटेड कोई चर्चा नहीं हुई थी.
उनके सामने नहीं हुई थी.
हाँ, उनके सामने नहीं हुई थी लॉर्डशिप. एंड उन्होंने जो रिस्पॉन्ड नंबर 2 है, एक्यूज नंबर 2, Sanjay Gupta kept him informed about the line of treatment and arterial septal defect which was detected in the daughter. Lordship, other जो बाकी के स्टेटमेंट्स हैं उसमें भी ये है कि हमको the complainant has told कि ऐसी कोई डाउरी वाली बात थी. जो 2 विटनेसेस इनके रिलेटिव्स ने कहा है वो भी हियर से बेस्ड है. उनकी खुद बात होती थी कंप्लेनेंट की डॉटर से. उनको कंप्लेनेंट की डॉटर ने कभी ये बात बोली हो डाउरी वाली, ये उन्होंने साफ डिनाई किया लॉर्डशिप. In my arguments, page number 35, I have mentioned, lordship, that the hospital staff and the housemaids, these are 2 independent eyewitnesses. They have not supported any of the story. जो हॉस्पिटल का स्टाफ है उन्होंने क्लियरली कहा है कि इन लोगों को बहुत अच्छे से टेक केयर करते थे जो डिसीज्ड है उसका.
वो रेटिट्यू है ना, ट्रायल नहीं है.
हाँ, ट्रायल नहीं है
सपोर्ट नहीं किया, वो मत बताइए किसने किया है, वो बताइए.
So the point I am lordship trying to draw is, एक तरफ एक इंटरेस्टेड विटनेस है जो कि आई विटनेस भी नहीं है और दूसरी तरफ आई विटनेसेस उसके स्टेटमेंट्स को रिफ्यूट कर रहे हैं. नो लॉर्डशिप, जो
रिफ्यूट कर रहे हैं यानी
तो वो वहां उपस्थित थे लॉर्डशिप. घर में जो मेड्स उपस्थित थी.
डाउरी की डिमांड के बारे में हॉस्पिटल की नर्स का स्टेटमेंट कैसे रिलेवेंट?
नहीं, डाउरी की डिमांड के लिए हाउसमेट्स का आई एम ड्राइंग लॉर्डशिप अटेंशन. एंड जो ट्रीटमेंट के
सामने थोड़ी डिमांड होगी.
नहीं, वो सुबह से शाम की हाउसमेट्स हैं लॉर्डशिप, दिन भर रहते थे वो. और इनका खुद का ऐसा एलिगेशन नहीं कि चुपके से अलग से मांगते थे लॉर्डशिप. नाउ मे आई काइंडली रेफर टू few judgments of the Honorable Supreme Court. Lordship, 498 जो है, जो petty quarrels between husband and wife हैं उसके लिए नहीं होता है. And a single incident of any violence अगर होता भी है, हमारे केस में तो single act of violence भी नहीं है which would fall under the extreme limit of 498A. अगर सिंगल भी इंसिडेंट है तो इट कैनॉट बी a ground for conviction under 498 lordship. This is honorable supreme court in Girdhar Shankar Tawade versus state of Maharashtra, page number 37 of the arguments I have mentioned. If suicide is left out, then in the event question of applicability of explanation A would not arise, neither the second limb of to cause injury and danger of life of limb or health would be attracted. ऐसा सुसाइड में करने चली गई थी, ऐसा कहीं भी एलिगेशन नहीं. In any event ought to be the proximate cause in order to bring home the charge under 498A. 1 month के बाद इन्होंने सारे डिटेल्ड एलिगेशंस लगाए हैं. And not yet. To have an event sometime back cannot be termed to be a factum taken note of the matter in the charge under 498. The legislative intent is clear to indicate that particular reference to explanation that there have to be a series of acts in order to be a harassment within the meaning of the explanation. Then only it is a criminal offense according to 498. Lordship, similarly in Manjuram Kalita versus State of Assam, which I mentioned on page number 37, relevant part of it, cruelty for the purpose of 498A is to be established in the context of 498A. It is to be established that the woman has been subjected to cruelty continuously, persistently, or at least in close proximity of time of lodging the complaint. Petty quarrels cannot be termed as cruelty to attract 498A. Lordship, then there is Madhavrao Jivaji Scindia versus others. It is also for the court to take into consideration other special features. This is particularly important because charge sheet has been filed and investigation is complete. So those other factors also have to be taken into account, and FIR cannot be taken as the gospel of truth. This is so on the basis that the court cannot be utilized for any oblique motive, and where in the opinion of the court chances of an ultimate conviction is bleak and therefore no useful purpose is likely to be served to allow criminal prosecution to continue. Lordship, now page number 39. State of Karnataka versus Munisame Honorable Supreme Court. The wholesome power under 482 entitles the High Court to quash a proceeding when it comes to the conclusion that allowing the prosecution to continue would be an abuse of the process of court, or that the ends of justice required the proceeding ought to be quashed. A court proceeding ought not to be permitted to degenerate into a weapon of harassment. So that is what has happened in the present case. Your Lordship has also quashed a matter in similar case, Anita Rai versus State of Madhya Pradesh, wherein it was observed that merely naming the sections and definitions is not enough. There has to be specifics. Now, then Lordship, Supreme Court in Vishnu Shankar Shukla versus another and State of UP. The duty of the Supreme Court has said that it is the duty of the Honorable High Courts to quash vexatious and unwarranted criminal prosecutions. They mentioned on page number 53, para 21, it cannot be expected even at the initial stage to accept all that the prosecution states as the gospel of truth, even if it is opposed to common sense or the broad probabilities of the case. On page 55, the court has opined that appellants are to be protected against vexatious and unwarranted criminal prosecution and from unnecessarily being put through the rigors of an eventual trial. Lordship, now there is a case where in very similar circumstances as in the present matter, there was an allegation of 304 be made just on the grounds that the wife had died, and ultimately it was found that it was a medical, she had some medical issues due to which she passed away. And the observations of the Supreme Court in that particular case are very relevant. The Supreme Court has said that the High Court ought to have considered the fact that because the daughter of the complainant passed away, she was extremely hurt, and because of that, the possibility of false implication is also much greater in such a case. Similar is the matter in our case, Lordship. So, Lordship, or conduct before the marriage, spending, or conduct after the marriage, our conduct during the treatment, and the absence of not a single piece of evidence which shows there is any demand, despite the fact that we are admitting their own WhatsApp conversations, which covers 110 days out of 124 days. So on that ground, Lordship, I am seeking that the FIR and charge sheet may kindly be paused because it is clearly an abuse of the process of the court.
May I, Lordship?
Just a minute, Charge has been framed by the trial court.
Not yet.
The trials have not yet started, sir. It's a very premature stage.
Under what section has the charge sheet been filed?
Lordship, 498A.
Where is that? In the charge sheet?
It is mentioned in the charge sheet.
Final report. This begins at page 64. Where are the sections mentioned? 498A 34.
Yes, Lord. Only.
Dowry Prohibition Act. So the entire allegations, they will be covered under the definition of dowry at or before the marriage, as consideration for the marriage of the said parties. So the allegations are regarding demand of dowry prior to the marriage also. This will be covered under 3-4, and as of now only charge sheet has been filed, maybe under 498A, but the court has the power to frame the appropriate charges. अब बोलिए.
अब सर मैं ये बोल रहा हूँ लॉर्डशिप
हाँ.
कि अब to look at only the allegations in the FIR is something, Lordship, I have cited a judgment of the Honorable Supreme Court कि when investigation is complete and there is material, reliable material, which should also be looked into.
So look into that.
ये material, इस material में Lordship before marriage में 51 lakhs हमने spend किए हैं. उन्होंने जितने spend किए हैं वो भी exaggerated है. 3-4 lakhs के spending को उन्होंने 11 lakhs Lordship बताया. अब
482 में अभी ट्रायल नहीं कर रहा है.
नहीं ट्रायल नहीं लॉर्डशिप, आई एम रेफरिंग टू द मटेरियल.
आपने शादी में खर्च किया.
हाँ
ठीक है. तो शादी में आपने जो खर्च किया बाहर वालों को बुलाने में, उससे क्या फर्क पड़ेगा?
सर उससे लॉर्डशिप फर्क ही पड़ेगा. इट शोज माय कंडक्ट. मैं आई कैन नॉट एट द सेम टाइम बी आस्किंग डिमांडिंग मनी फ्रॉम देम इफ आई एम स्पेंडिंग सो मच ऑन द मैरिज.
सारे इंस्टेंसेस तो बताए हैं एफआईआर में भी, स्टेटमेंट में, कि फिर बुला के बोला कि ये खरीदो, फिर ये खरीदवाया, बोला कि नहीं खरीद सकते, फिर भी खरीदवाया.
लॉर्डशिप ये सब एलिगेशंस इन्होंने 1-1.5 महीने बाद आफ्टर द डिसीज पास्ड अवे किया है.
ओनली ऑन द ग्राउंड ऑफ डिले.
No, not only on the ground. That is but one of the grounds, Lordship.
One of the grounds.
One of the grounds. And the first complaint which she made, if you kindly look at what she has been citing on page number.
That I have understood. It doesn't mean कि not one said means cannot ever be said.
Lordship, but the possibility of a false implication is very high. If the
in 482, I have to see that there is absolutely no possibility of a conviction.
No,
nothing is there on record.
Your Lordship also has the power to decide whether there is an abuse of process, even when ingredients are made out. Ingredients may be made out, but if the other circumstances are such that the ingredients are completely, the possibility of that happening is very low.
Yes.
Then that may kindly be considered, Lordship. And what they have mentioned in the WCD complaint, dowry kuch hai nahi, demand kuch hai nahi. And a person who can come to the Honorable Court and argue her matter in person can certainly file an online FIR. For 1.5 months, if they had any fear of coming to Indore, they could have certainly filed an online FIR. They did not do so. So, Lordship, all the circumstances, spending before marriage, after marriage, the way we treated them, the way they made a false allegation that we are responsible for the death. They made a false allegation that we are responsible for that. Several medical boards have stated otherwise, that we have given them proper treatment for COVID. So, the continuous false implication. And if your Lordship looks at page number 42 of my compilation, 54, in her previous writ petition, she was asking action to be taken against several doctors of Bombay Hospital and several investigating officer.
Confined to the facts of the
So
case.
the reason why I am referring to that, Lordship, is
YouTube
there.
बंद करना तो जल्दी हो जाएगी
No,
क्या?
Lordship, the reason why I am referring to that is that there is a tendency to falsely implicate anybody whose name is there. So, given that conduct also, it may kindly be looked into कि what she is saying in the FIR may not alone be looked into, and the other circumstances may kindly.
पूरा देख के करेंगे.
Lordship, and we have filed the petition on behalf of the husband, the father, mother, and the brother-in-law.
Lordship, with your kind permission, can I
Not
submit
required.
this?
Heard this.
Citations.
Not required.
Lordship, before I leave, may I just let you know one thing? There are many important phone calls and recordings in my phone.
Dismissing the petition.
Oh, thank you.
Yes.
Obliged.